Hello, 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 everyone. This is Ifama Odolami. Good morning, good morning. My name is Ifama Odolami. For those that don't know me, I'm an immigration attorney in New Jersey, but we have clients in all 50 states. And I'm on Instagram. Hi, Instagram. Hello. I'm on Facebook, and I am on YouTube. And I'm really excited to bring this topic to you guys because this is a topic that is near and dear to my heart. It's VAWA, Violence Against Women's Act. So lately, I've been getting people call my office because their VAWA cases have been denied, right? They might have filed it themselves, or maybe they used a notario or whatever. I don't know. But the cases have been denied. So basically, it takes like 2 years to 2.5 years before, you get a decision from VAWA. So basically, it shows that the past 2.5 years have really been a waste. So if they're lucky and they have the time, they can refile. And when I say if they're lucky and they have the time, I mean if maybe they're still married to the U.S. citizen or green card holder, and or if they divorce the person, it hasn't been 2 years, because if you're divorced from your U.S. citizen or green card holder spouse, you have to file the VAWA within 2 years of the divorce. So if they're lucky, they get to refile it. But VAWA is a long process. So you really want to do it the first time and do it right. So honestly, of course, I recommend that you use an attorney who is experienced with VAWA cases. So I'm going to go through the things that you need to have, the way to put your petition together so that you can maximize your ability to get your VAWA case approved, okay? So let me put the comments on in case people have comments. Now I'm going to just go through what I have to say, and then I'll look at the comments, and if you have any questions, I'm happy to answer them. So we all know what VAWA is, Violence Against Women's Act, right? And VAWA is for men and for women. Children can file too. Parents of U.S. citizens can file too. So if you have a VAWA petition, the first thing you need to show is that the abusive person, is a U.S. citizen or green card holder. Now remember, for parents who are filing VAWA, the child has to be over 21 and the child has to be a U.S. citizen. So if you're a green card, if your child is a green card holder, the parent cannot file VAWA. So for that parent, the child has to be a U.S. citizen who's over the age of 21. So I just want to put that to the side. So every other person, a spouse or child, can file if the person is a green card holder or a U.S. citizen. That's the abuser. So the first thing you need to do is you need to show that that person is a U.S. citizen or green card holder. And the reason this is important is because a lot of times the non-citizen who's been abused may not have this information, because of the nature of the abuse. If your abuser is somebody who is hiding the documents because they don't want you to file the paperwork, it might be a little difficult to get that information. So what do you do? Well, first of all, if you can get the birth certificate of a person showing that they live here in the United States, that they were born here in the United States, or they were naturalized, a naturalization certificate, that would be great. If you can't, if the person naturalized and you know the A number, that would be helpful because USCIS is able to pull up their naturalization certificate, right? Now, in my firm, we've had to think outside the box for some of our clients. And some of the things we've had to do is we've really had to be like Sherlock Holmes, digging into records. We've been able to pull out voting records for the abuser to show that the abuser is a U.S. citizen, because only U.S. citizens can vote, right? Sometimes, if you're in some states, the abuser's date of place of birth would be on the marriage certificate. So if you have a marriage certificate, take a look at it and see if it indicates that USCIS has been known to accept that as proof, right? And there was a case we had where we had nothing. My client had nothing to prove that his spouse was a U.S. citizen, but the spouse had filed for the children, but he didn't have any of the documents. But we had one of the child's A number, and we were able to do a FOIA request and get the information. There are many ways to get this information. Sometimes you can just get an affidavit from people who know for sure that the person is a U.S. citizen. If all else fails, do a FOIA, Freedom of Information Act, right? And if you do a FOIA, you want to give USCIS as much information as you can. You know, if you have the person's social security number, their full government name, um, date of birth, you know, that kind of information, and just tell USCIS, I know he or she's a U.S. citizen, but I don't have uh, actual proof of it, but this is all the information I have. So here, help me with this, you know? So see, not too bad. So you do have to give, show proof that the person is a U.S. citizen or green card holder, because without that, you cannot get any relief under VAWA. You might get relief under another type of visa, maybe U visa, maybe T visa, if your fact pattern qualifies. So now another thing is, if you have an approved I-130, maybe the person has filed for you already and you have an approved I-130, you can submit that as proof that the person is a U.S. citizen or green card holder. All right. So another thing that you need to prove, number two, what else do you have to prove? Number two, you have to prove evidence of the qualifying relationship, right? You have to prove evidence of the relationship that demonstrates the familial legal relationship to the U.S. citizen. So what are we talking about here? So relationship, if your abuser is your spouse, you want to show the marriage certificate that you're married, right? If your abuser, now if you're in a state that recognizes common law marriages, I think there are 13 states in the United States that recognize common law marriage, just show that you have held yourselves out to be a married couple consistent with the laws of that state. If you marry somebody and maybe in your country, maybe you were married through customary marriages, USCIS will recognize that customary marriage as long as your country recognizes it. So you don't have to be married in the United States for the government to recognize your marriage. As long as the country that you're coming from recognizes your marriage, USCIS will recognize it. So the same goes for what you may call it, the divorce, right? That's a big thing, and I'm going to get into that, right? So basically, if you're married in a customary manner, and your divorce in your country requires that you get divorced in a certain way, maybe return of the dowry or whatever, USCIS will recognize that divorce, right? So I'm going to come down to this divorce because this is a big topic, right? I want to talk about this. This is a big topic. This is a reason why many VAWA cases are denied, right? So let's go back to proving familial relationship. So if you're filing as a child or as a stepchild of an abuser, U.S. citizen abuser, green card holder abuser, you want to show that the qualifying relationship, which is the relationship between your parent, your biological parent, and your step parent, happened before you were 18. So that makes you the stepchild of the abuser, right? You want to show that. Now, ultimately, if you file, remember this, if you file a VAWA petition, your children can be derivatives, even those who are over the age of 18, before the age of 21, they can be derivatives of your application. So remember that, right? So, so let's talk about divorce, because this is a big topic which has ruined many great VAWA cases. So people file a divorce in their country, and then USCIS says it's not a real divorce, it's a fraudulent divorce, it's a fake divorce certificate, right? And if your divorce certificate is fake, that is from your prior marriage, right? Because if you're married to a US citizen, that marriage is only valid if your prior divorces are properly terminated. So if you're married to a US citizen or a green card holder, that is only a valid marriage if your prior divorces are properly terminated. So let me give you guys one tip, right? This is really important, so I'm going to say it twice. If you're here in the United States, you don't have to go back to your country or have somebody in your country file the divorce for you. You can divorce your spouse in your country from the United States. And the good thing about it is you will have a United States divorce decree, which USCIS will of course not, have any problem with. They typically have a problem with some divorces in certain countries where their documents are frequently found to be fake. And USCIS can find this information out because a lot of this documents are online, or sometimes they will have their officers go to that state, go to that, maybe the people in the embassy go to that country to go in there to see if this divorce decree exists in that courtroom or wherever it is, right? So if the thing is this, if your divorce decree is fake, or USCIS says it's not proper and you cannot authenticate it, it doesn't matter how bad the abuse is. Your marriage to the US citizen or green card holder is void, 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 right? So let me say that again. If you do not properly terminate your divorce, your subsequent marriage to a US citizen or green card holder is void and you cannot get any benefits from it. There is a bigamy exception though, let me tell you this. If you're married to a US citizen and that US citizen was married before and didn't terminate their relationship, but you didn't know that they didn't terminate their prior marriage, and you believe that they were available for you to get married to, and you had a marriage ceremony with them, there is something called a bigamy exception, right? And the reason there's an exception to that is because you are a victim. You did not realize that that US citizen did not terminate their marriage. You believe that they were properly, available for you to marry. You marry them in a ceremony, only to find out that they were not married. So you can still file VAWA, even though technically your marriage to that US citizen is not a valid marriage. But on the flip side, if you are the one, the non-citizen, who didn't properly terminate their relationship, their marriage, that bigamy exception does not work for you. Okay, so I hope you guys understand the difference. All right. So let's go on to how to prove the familial relationship. I think I talked about, so if you're a parent who's trying to file VAWA because you have a child who's over 21 who's been abusive, you want to have a birth certificate showing that your name must be there as the parent of that child. So that's the proof of the familial relationship. Okay. So let's see. Next thing. Let's see. Another thing I want to talk about is same-sex marriages are legally binding as long as it's recognized in the country where you got married. So the theme to understand from all of this is if you follow the laws of your country, of the country where you're from, and you get married pursuant to those laws, USCIS will recognize those laws, except for laws that are, shocking to the public conscience, or such as, laws where you can marry more than one wife. USCIS does not recognize polygamy. It's actually a crime in the United States. So if you're married to more than one person, it's called bigamy. It's a crime. Okay, so that would not work. So what else? So the third thing you have to prove is that you and the abuser resided together at any time in the past. So in previously, there was a law that said you had to have resided together during your marriage at some point. But there's a new law that came out that says it doesn't matter anytime. You must have resided together at some point in the past. So that is a new law that really works. So as long as you live together at some point in your relationship, you've satisfied the living together relationship. Now, another thing that's really great about the residency requirement, it doesn't say that you have to have lived with a person, with your abuser, for any amount of time. So it could have been 1 day, it could have been 3 weeks, no matter. As long as you can show that you did live with them at some period, at some period of time. And you have to show this by providing documents that prove that you've lived together, such as maybe a lease, utility bills, a lease, utility bills, maybe a letter from the landlord, because a lot of people may not have leases because they are, I don't know, maybe because they don't have the papers, they may not be able to be put on the lease. So if you have a landlord who is willing to send an affidavit saying that you lived from there to then you have receipts of the payments you made, that kind of stuff, that could qualify. The idea is to just get as much information as you have to prove that you live there, or that you live together at some point. So now let's talk about other proof, such as medical records, insurance policies, if you have bank statements, school records listing the parent, just anything that shows that you and this person were living together at some point. So now let's talk about the abuse. The crux of VAWA is the abuse that you have suffered, right? Now I've heard clients talk about how maybe previous attorneys told them that their cases weren't, they didn't have a good case because they didn't have a police report. And I'm here to tell you that you do not need a police report to file a VAWA case. As a matter of fact, the law is really clear that it's physical battery or extreme cruelty. So extreme cruelty basically ties into the fact that they know that it does not have to be physical abuse. It can be emotional, it can be psychological, it can be financial. Is this person taking all your money? Is this person forcing you to work? Is this person treating you badly, threatening you, controlling you, isolating you? Then the emotional abuse, psychological abuse, the whole gamut of it is so fact specific, right? And I found that a lot of people don't even realize that they're being abused, when it's emotional or psychological abuse, because maybe their upbringing did not consider that abuse. And I'll give you an example, right? Excuse me. Like, say I'm Nigerian, so in Nigeria, right, I remember I was watching a video, or where people were talking about something that happened where a woman cut her hair or colored her hair. I can't quite remember what she did, but she came back home and her husband was mad and chopped off the hair or something, and basically said that she had no right to do anything to her hair without talking to him first, right? And a lot of people there were like, well, he paid her dowry, she should know better, the man is the head of the house and she can't go doing these things without talking to him. Well, in America, that's considered controlling behavior. That's abusive. So if you are somebody who grew up in that culture where you're not allowed to do anything to your personal self, you're not allowed to dress a certain way without getting permission from your husband, and you think it's okay. Listen, it's not okay in America. If you live here, if you're married to such a person and the person is a US citizen or green card holder, you can file a VAWA application based on that. And I'm sure there are other things that's going on in that relationship that show the control that that person is wielding on the non-citizen's life. So we've talked about different types of abuse. We've talked about especially the threats. Threats are a big thing with abusive marriages, especially when you're married to a US citizen or green card holder and they're filing for you. A lot of time they're holding that over your head. Well, if you don't do this, I'm not going to show up for the interview. If you don't sign this, I'm not going to give you this document so that we can file your application. Or if you don't behave yourself or don't do what I want you to do, then I'm going to divorce you. And guess what? You're not going to be able to get your papers. There's always that threat, or the threat to call the authorities, like, if you do this, I'm going to call the police, and guess who? They're going to believe me because I'm the US citizen. And if you've been watching the trial of Johnny Depp, right, you'll see that, this is, it's the same thing, like I think Amber had said to him, who's going to believe that you, Johnny Depp, is being abused? Who's going to believe you? You're a white man. Who's going to believe you? So when they say things like that, the victim, the non-citizen especially, who is already hiding from the police because they are afraid of being deported, they're not going to call the police if they're being abused because they're afraid. So that level, that kind of threat, that control, that that behavior, the government recognizes that it's not right. They don't want you to stay in a toxic relationship because you're looking for a green card. They don't. So you have a way out. You can file VAWA. You can get your green card. You and your abusive partner does not need to know. and they will not get into trouble, because that's another question I hear all the time. Well, I don't want him to get into trouble. I don't want her to get into trouble. They won't get into trouble. VAWA is confidential. All right. So let me say hello to a couple of people who signed in. Hi, Shauna Everblessed. Thank you for signing in. Nice to meet you. And then Hash says, what's the best evidence to add when you're requesting removal, proceeding, dismissal? So you know what? I'm going to come back to that question. Let me finish this, and then I'll answer all the questions. So now, and sometimes abuse can be the person threatening to hurt your child or threatening to take your child away from you. Well, if you don't behave yourself, you're gonna get deported, and our child is gonna stay here, or they're even threatening to harm your pet. So abuse is so fact sensitive, right? But you feel it if you don't feel that you're being treated right, and it may not be one thing. Typically, it's a combination of different types of behavior that together rise to the level of abuse, right? And USCIS, the requirement that they look for in analyzing this abusive behavior is just credible evidence, right? So, and I say this because there are a lot of people who tell, oh, I don't have a police report, I don't have a medical report, I don't have this, I don't have that. It's credible evidence. And sometimes the best credible evidence could be your story, you telling your story in a declaration, right? Explaining what happened, how it happened. And the important thing is that you want to be able to put as much information in there, right? So that the person who's reading can hear your voice. It's credible, they understand it, right? So typically when we do our declarations, and I have a newsletter on how to write a declaration, if you look through my page, you'll see it somewhere. You're looking to explain how you met the person, how the relationship grew, why you decide to get married to the person, and how the abuse started, the worst abuse, this made you feel, so you want to explain to them, because USCIS has this thing about marital tension. Some of the things that you may consider abuse, they consider marital tension. So it's very important for you to tell your story in a compelling way, and that's what we do in my office. Our interviews with our clients regarding what they've been through sometimes takes 2 to 2.5 to 3 hours, because we really get into it. We want to make sure that the client's voice is heard. All right. And some of the time, the questions we ask the client, they may not, a lot of times they're not willing to share, because this is trauma for a lot of people. It's really traumatic. So they're not really ready to give you this information right off the back. And we've been known to have a second interview, because sometimes, you have to allow them to go through the emotions. And sometimes, a lot of times, especially for psychological abuse cases, we have the client will do a psychological evaluation, and the psychologists, they do a really great job in unearthing information, really painful information that the client does not want to share. So those are things that you can provide to show what you're going through, so that your voice is heard. All right. So now let's talk about physical abuse, right? That, if it happens, you have pictures, that's helpful. If you have verbal abuse and the person is texting you, cursing you out, embarrassing you on social media, you can, all of that is evidence. Sometimes people feel they have no evidence, but by the time we do the interview with them and we go over what they're telling us, we're like, well, can we have, this happened to you? Well, do you have any something in the house that shows this? Or somebody picked you up. Can we get an affidavit from that person explaining what happened, what they knew, how they came about this information? I guarantee you that your case is not as lacking in evidence as you think. You just have to go through it with an attorney who is familiar with this type of cases, for them to be able to bring out stuff that meets the burden of the credible evidence and can get your story told. All right. Now, what else? Let's see. So we've talked of evidence of abuse, which can be reports and affidavits from the police, such as if you have a temporary restraining order called that you have against a person, or if the person has a temporary restraining order against you, because sometimes these abusers know how to, work the system. They, I've had clients who their spouse would hurt themselves and call the police so that it looks like the abuser hurt them. I mean, that is like more common than you realize, right? Or you have school officials, especially for children who are being abused by their parents. Maybe there's a school official who's noted something in the records. If you've talked to a social worker, you've talked to your priest or your pastor or your clergy, any of this, together by themselves can provide that compelling story that you need to tell. Now, the other thing is, for VAWA, you have to be prove that you're a person of good moral character, right? Which means that you don't have any criminal records. However, if you have criminal records, does not mean you cannot qualify for VAWA, because it depends on the crime, and it depends on, there are things that can be done to still make you VAWA eligible. So VAWA typically looks at the last 3 years, right? So you're required to get either a police clearance from everywhere you've lived for more than 6 months in the past 3 years, or you can get an FBI report, fingerprint. You send them your fingerprints, they send a report showing that you have no criminal history, right? And if you do have criminal history, sometimes you need to rehabilitate your person. Maybe you can get affidavits from friends, family, friends, co-workers. Always depends on the crime. So if it's a felony, that's really a hard one. But if it's what they call a crime involving moral turpitude, maybe shoplifting or something of that sort, that's something that can be worked on, especially if the reason you committed the crime might have been related to the abuse. So now let's talk about the big one that I want everyone to know. Listen up, listen. You cannot be eligible for VAWA if you cannot prove that your marriage is a good faith marriage. You cannot be eligible for VAWA if you cannot prove that it's a legitimate marriage, which means that you entered into this marriage in good faith because you wanted to be with your spouse and not only for immigration purposes, right? And that is a harder burden, because sometimes you have an abuser who is aware of the things that you need and they're hiding the stuff. They don't want you to have, they don't want you to get a joint bank account with you. They don't want to file taxes with you. They don't want to do all of this stuff with you, right? However, does that mean that you cannot you cannot get your VAWA approved? No, it doesn't mean that. You just have to provide a compelling case in the totality of it. Now, if you married somebody just for the purposes of getting a green card, like it's a sham marriage, a fake marriage, you cannot apply for VAWA. I want you to know that regardless of how badly that spouse treated you, right? So how do you prove that you have a valid marriage? Well, the rules say that they want you to show, insurance policies showing that both of you are listed as beneficiaries for each other, joint leases, income tax forms, bank statements, evidence of courtship. That's really important. A wedding ceremony, shared residence, and other shared experiences, right? And a lot of times, depending on your situation, we're able to get more information if you're in that relationship where your spouse is hiding information and doesn't want you to get access to the things that could prove that you have a bona fide marriage, right? So that is pretty much it. Let me take a couple of questions because and then I will. So let's see. So Hash says, hi Hash, thank you for tuning in. So let me read your question. What's the best piece of evidence to add when you're requesting removal proceeding dismissal? So Hash, when there's a new law that says that if if you're in immigration court and you have an alternative way of getting your green card, that ICE attorneys, can dismiss the case, right? Terminate the case is the word. Now, the evidence they're typically looking for, it typically has to do with what is that other pathway to citizenship. So if you're married to a U.S. citizen, right, they may want, it all depends on the ICE attorney. Sometimes they'll ask for if you have an approved I-130, or if sometimes they'll ask for the affidavit of support for you to put it in. I've noticed that it really depends on the attorney, the ICE attorney who's working on the case. But the most important thing is you have to show that you have another path to getting your green card so that you can get out of immigration court, right? And getting out of immigration court, also, you want to make sure that that's the best thing for you, because there's some people that it might be better for them to stay there so that their case can be adjudicated there by a judge. So you want to talk to an attorney because this is so fact sensitive. So hi, Olawale Abiola, how are you? Olawale says, which state are you in? Olawale, I'm in New Jersey, but we have clients in all 50 states, so it doesn't matter where you are. As long as it's family-based immigration or humanitarian-based immigration, we're here to help you. And so Portia Stubbs. Hi, Portia. Portia says, awesome information. Hi, Portia. I'm so happy that you're finding this helpful. Please be sure to share it with somebody who may find it just as useful. Now we have Shauna. Shauna says, when you file for VAWA, can you still live with your spouse? Shauna, this is a great question, and I'm happy you asked this question, because a lot of people do not know that if you file for VAWA, you can continue to live with your spouse. There's no requirement for you to be divorced from your spouse. You can live with your spouse, you can leave your spouse, you can divorce your spouse as long as you file the VAWA within 2 years. It's really up to you. And if you're living with your spouse, right, you want to make sure that you have a safe address. In my office, all our VAWA cases, we use our address as a safe mailing address, because we want to make sure that none of the mail that comes from USCIS goes to the house, because we don't want the abuser to know that you're filing VAWA. And another good thing is that the USCIS by law cannot tell the abuser that you're filing VAWA. It's confidential. And also they cannot use any information that the abuser says about you. For instance, if the abuser calls USCIS and says, it's a fake marriage, you did this, they can't use any of that against you in your VAWA case. So you need to know that you're more protected than you realize, right? So, hi, Joe. How are you? So Joe says, when you're invited for the second interview and your spouse refused to show up, if filing for VAWA, will they cancel your present EAD and AP? Okay, now this is a great question, Joe. So let me answer it. So if you filed for, if your spouse doesn't show up for the interview, the I-130 will be canceled because that's their application. However, the I-485 belongs to you. And if you act fast, you can save that I-485. When I say if you act fast, if you're able to file your VAWA application either before the interview, if you know that your spouse is not going to show up, or shortly after the interview, you can ask for your I-485, which is the forms that you fill that gives you the adjustment of status, that gives you the work permit and the advanced parole. You can ask that it be moved to your VAWA case. That way you save $1,225. So we do that by way of something called a request for abeyance. And I've noticed that some officers are not even aware of it. So sometimes you kind of have to explain it to them. There's case law we attach to our letters that tell the officer that we're allowed to request this. All right, that's a really great question. Thank you, Joe. And then Hash says, thank you for the details. Great job. You guys, it's been so awesome being with you guys. And so I'm going to sign off now. But I think I answered I went through all the stuff I wanted to go through. So please follow me on Facebook, Instagram, LinkedIn, YouTube, and even TikTok sometimes. I'm on TikTok. So that if I come on social media, I have information, you'll get that information as soon as I sign in. So I think I have one more question. So let me ask this question and then I'll have to go. Shauna says, I filed for VAWA, now my spouse decided to help me. What should I do? So Shauna, this is I guess I would say it's a personal decision. But I feel that it's best to proceed with your VAWA case, because I don't know your spouse, I don't know what happened, but if you're in an abusive situation, do you really want that person determining your ability to get a green card? You filed VAWA for a reason, because you were in an abusive relationship, right? And as long as that person is in charge of filing if they file a petition for you, they get to decide whether they can continue with the case. When you file with VAWA or under VAWA, you decide. You have the power. It's a self petition. That person is not in the picture anymore with regards to how you get your green card. And I would think that this is something that you want for yourself. The sense of empowerment that you found when that you have when you have filed VAWA is amazing, because you know that it's not dependent on this person being in a good mood to show up for the interview, or dependent on them giving you this information for you to file your case. So honestly, if you ask me, I would say go on with your VAWA case. So, all right, guys, thank you for signing in, and I will see you guys another time. All right, take care.